domestic succession. So Rudy passes away. Next one, please, Zach. Yeah. Freddie, I have a question for you here. On what basis do the Indonesian succession laws apply to Pak Rudy's inheritance?
Okay, thank you. So if Pak Rudy still keeps the Indonesian citizen, so meaning that the Indonesian succession law will be applicable. But this one again, like we discussed earlier, we need to honor as well the community property, because the community property should not be part of the inheritance assets.
Okay.
In terms of just the succession laws, we'll assume that Rudy is not within the Muslim faith. So how will the succession laws apply in that case if he's a non-Muslim?
Yeah, this is on the non-Muslim that basically the citizenship of Pak Rudy would play a very significant role here.
Okay.
So, yeah, the next question is on forced heirship. But let me split this in two. Can you first, Freddie, just briefly explain what forced heirship rights are? And then do the Indonesian succession laws include forced heirship?
Okay, thank you. Basically, in Indonesia, we know that this type of concept, maybe the similar one is a legitimum porsi. So that the heir rights, let's say the kids, is protected up no less than 50% of their original rights. Let's say the kids supposed to have 30% or 40%. The rights can be reduced, but cannot be lower than 50% times the 30 or 40%.
Okay. So, okay, let's move on to one. Is it possible for forced heirs to basically agree that their forced heirship rights can be changed, or can they waive them altogether?
Okay. So of course, if they agree together and they agree to make their own calculation, that's possible. Let's say the kids supposed to have 30%, but agree to just have 10%. That's possible. Or sometimes the kids simply reject the entire inheritance, but the other kids agree to give him or her certain compensation. That's also possible.
Okay. That's respected. All right. The next question, does the Indonesian succession law permit any testamentary freedom?
Testamentary freedom, yeah. This one is recognized, but still the testamentary freedom must honor or cannot breach the forced heir rights or legitimum porsi, and also cannot touch the matrimony, the joint assets that are not subject to the inheritance.
So what's the percentage of the non-community property, so the free estate, what percentage can actually be disposed of by a will without any forced heirship right?
This one is not clearly regulated, but in short, everyone can do the testamentary, but the final calculation must be made and must honor the forced hair rights.
Okay.
Great. Let's move on here. Freddie, under the Indonesian succession law, is there a possibility for Rudy's heirs to claim back the asset that has been transferred to the Hong Kong Trust?
In general, yes, if the heirs do not or will not receive any benefit from that trust. In case the transfer breach the legitimum porsi.
Freddie, does it make a difference when the transfers were made into trust? I mean, this could have been many, many years before Rudy's death. Does it make a difference to the clawback when it occurred in terms of the gift into the trust?
In general, no such limit, but the basic statutory limitation for the civil code, basic statutory, not only about the clawback of this 30 years, the basic one, and then the clawback must be done no later than 3 years after the distribution.
Okay. So, what about the indirect holding of the trust in the Indonesian trading company? Is there any chance for them to claw back that holding?
Okay, this one is depend on the structure of the transaction. But in case the asset that transferred by Pak Rudy here is the shares in Indonesian trading company, so the shares in that Indonesian trading company may be subject to the clawback.
So in that way, the heirs can short circuit the Hong Kong Trust and just go directly against the domestic Indonesian company. Is that right, Freddie?
Sorry, can you repeat?
Is it possible that the heirs that want to do a clawback claim against the foreign trust, if they want, they can effectively go against the domestic Indonesian property and not bother to take a claim out in the Hong Kong courts? Is that right?
If the asset that Rudy transferred that to the trust is the Indonesian asset, yes. Let's say Pak Rudy own the shares in the Indonesian trading company and the shares transferred to the foreign trust. And because of the transfer, the legitimum porsi breach.
Right. But if instead he transferred money to the trust and the trust used that money to acquire shares in the Indonesian company, would that make a difference?
That's would be different because the assets which had been transferred is not the shares. So the transfer itself is the object of the
Right. Okay.
All right.
So I think from the Hong Kong perspective, Joe, I can just answer, Hong Kong does have protections, as does Singapore, against heirship and succession rights in this way. So there would be some protections in the Hong Kong courts against the forced heirs being recognized. There'd be some preliminaries to go through with respect to sort of Rudy creating the trust during his lifetime, transferring the assets during his lifetime. And then there's some deemed rules on his capacity to do so, which generally allows that if he transferred assets, let's say under Hong Kong law, and they were lawful, then that would be fine. Rudy would be deemed to be a valid transfer of assets into the trust. So there are anti-clawback claim protections in Hong Kong, which would, in this instance, defeat or would likely defeat any claim being made to claw back through the Hong Kong trust.
Okay. And those rules in Singapore and Hong Kong are effectively, they work the same, right?
Yeah, in effect, the Singapore ones are a little bit older and they're a bit more prescribed because they effectively only apply to non-Singapore domiciliaries. The Hong Kong one's a bit more clearly expressed. I suspect it's the same draftsman that both rules are emanating from, but they pretty much follow the same principles. It's not a fully sort of comprehensive firewall because both Hong Kong and Singapore don't position themselves as aggressive international financial centers, but they will be sufficient to defeat this sort of claim.
Okay, thanks. Let's move over to John.
So
John,
from from a succession perspective, I think important to also remember, like when we talked about marital property, this is a state-by-state determination. So we'd look to see, well, where are the company shares kept in the U.S. or outside the U.S. In which particular state are they kept or custodied in the banking relationship. So whether it's Indonesia or U.S., I think is first going to look at where that movable property is located. With the land, it's more about immovable property. So we look exactly where the land is located, and that state's succession rules. There will be federal estate tax complications arising from the land at a minimum, and most likely the stock, the shares as well. But there is a pretty simple, straightforward manner to address that and shield against the imposition of that U.S. estate tax, and that's holding those assets not in your own individual name as a non-U.S. person, but in an offshore company's name, and that shields against the imposition of the U.S. estate tax when Rudy passes away.
Well, John, just a matter of interest, John, when it comes to the succession to U.S. company shares, does the US apply effectively looking at the domicile of Rudy at death? Is that what they're looking at to make that determination?
Yeah, I think first of all, absent any contention and movable property, you're going to have a deference to that. Even with a contention and movable property versus immovable property, you're going to have maybe still I'd say maybe a slight deference to that, but you're bringing in the complication of a challenge that could be made under the actual location of where those shares are custodied. So we always want to see an individual in this situation with U.S. assets or U.S. heirs, have a chat with U.S. counsel, see if we need to look at separate wills, so that we're in a testate, not an intestate succession, or maybe we could combine wills, as long as we liaise with Indonesia counsel to make sure that we're not recommending anything that just gets invalidated by the primary location of the will.
Yeah, because presumably the Indonesian forced heir rules will be applied because of the movable assets. So it will be importing the Indonesian succession law rules, which will contain these forced heirship rights.
Yep.
Yeah.
And again, absent a contention, I think the U.S. would respect those. The U.S. doesn't have forced heirship in that regard. They have one state that's based on the civil law system, Louisiana, but back in the 80s, they kind of got rid of any of those concepts of forced heirship, even in Louisiana. There are statutory protections. They tend to fall more towards spouses, though, than any children protections in a protection concept for heirs.
Okay. So we move on to the next part.
Yeah, so from a BVI perspective, yeah, with succession will apply. So BVI will apply usual common law principles. They'll look at the domicile of the individual at death. And in this case, that will be Indonesia. The BVI company shares are movable assets. So BVI would effectively apply Indonesian succession law. If you have a BVI will, which seeks to override the, let's say, the forced heir rules under the Indonesian succession law, then that would effectively not be effective. So it wouldn't be a sort of essential validity of that will wouldn't work. So it would have to comply with, and that's what BVI would do. It would defer to the Indonesian succession law. And if that succession law contains these forced heirship rules, then that's the way in which this property will pass. Whether they attempted a BVI will, or whether or not it was effectively a BVI intestate, these are movable assets and they would be subject to whatever Indonesian succession law provides. That would be the ordinary English principles being applied.